Elaine Kasket. I'm a longtime scholar of Death in the Digital and the author of All the Ghosts in the Machine, the Digital Afterlife of Your Personal Data. I'm also a professor of psychology at the University of Wolverhampton, primarily associated with the cyber psychology course team. I am not a lawyer, but largely thanks to my conversations with many of you, I have a reasonably good grasp of the legal and regulatory state of play regarding posthumously persistent digital material. I've explored legal dimensions in my work, including the psychological and the emotional consequences of our legal and regulatory landscapes. And insofar as that goes, the law feels quite relevant to my core field of psychology. It's beyond question that digital assets and the keys to them are practically, financially, and emotionally consequential to those left behind. And a state that cannot be closed because of complexities with digital assets is not fun for anyone. There's also no question that the ongoing existence of digital remains is important to some grievers, sometimes critically, whether or not they access them. There's huge and unpredictable variation in this, but people do continue bonds with the dead using digital and online remains of various types. The position I'm about to offer is a provocation, partly because it seems odd from a psychologist, and partly because it bucks existing trends. I put to you that the practice of memorializing social media accounts has more cons than pros, is ultimately unsustainable, and should be radically rethought. I propose that social media platforms back away from assuming responsibility for wholesale, indefinite preservation of the data of the deceased. Social media platforms were not conceptualized or designed as memorial or legacy platforms, and their first responsibility is to the rights of living users under the law, notably their data privacy. On Data Privacy Day in 2020, Mark Zuckerberg posted an item on Facebook Newsroom headlined, "Starting the Decade by Giving You More Control Over Your Privacy," acknowledging that the company had some ways to go in providing stronger privacy protections. I argue that this is one such area. The data of the dead on social media platforms are inextricably interwoven with the data of the living. Dead can legally, if not uncontroversially, be employed in various ways to gain monetizable insights about living users. With sophistication and accessibility of deepfake and AI technologies increasing, and methods for hacking and accessing data that is otherwise useful for criminal purposes on the rise, the vulnerability of estates and living persons is increased by the ongoing existence of this data. As time goes on, the environmental costs of storing huge amounts of data of the dead will become considerable. And when one considers the whole of one's digital material and devices, access to devices or accounts by any person who is not the executor of the estate may constitute a threat to probate and the disposition of the estate under the law and in accordance with the deceased's intentions. But you might wonder, what of the experience of the bereaved? When I interviewed Jed Brubaker for my book, I think the adjective he used to describe the delete upon death policy that Facebook used to have is horrible. I have no doubt that it was experienced as horrible by the bereaved, and this does not mean, however, that it was the wrong course of action. All things considered, in retrospect, I wish the policy had been maintained, that Facebook had rejected responsibility for maintaining the data of the deceased for memorialization purposes. It might have helped prevent us from getting where we are now. We are now in a situation where we do not own and or cannot control digital information held by third parties. As privacy lawyer Al Gadari reminds us, access is 9/10 of the law. Our expectations have been shaped towards assuming that this material will be preserved by these sites, and in fact, that is their role to do so, their ethical and moral responsibility. As with so much else in modern life, we have unshouldered responsibility for these things onto these platforms, allowing them, and then tasking them or expecting them to hold on to our stuff, to manage us, care for, or respond to us in grief. We saw this expectation in the backlash against Twitter's planned cull of inactive accounts back in November and December 2019, which they hastily walked back. And now they've gone in what I believe to be the wrong way to memorialization of accounts. This perceived emotional, practical, moral responsibility, the preservation of the dead and maintenance of the digitally accessible dead, form one of the threads and the ropes binding us to these platforms, one pillar of a relationship of increasing dependency. Grief is an extremely private experience in that it is entirely idiosyncratic and linked to or mirroring of the idiosyncrasy of the relationship in life. In the headline of Facebook's Data Privacy Day article, one word caught my attention: starting the decade by giving you more control over your privacy. Giving. You cannot give something that you don't have, that's not in your power to gift. If a social media platform can hand me control over my privacy, it must possess that control already. If Facebook are really serious about trying to restore what they've taken away, this should form part of it. In a chapter that I'm currently writing with Morna O'Connor, a fellow scholar of Death in the Digital, we address 3 dead grief concepts that are being revived in the digital age, and revived partly through the machinations of technology companies, including the terms and designs of social media. One dead concept is that there is a normal or healthy or ideal way of grieving, thoroughly debunked by virtually all research. Another dead concept is that technology helps or hinders grief. But when we acknowledge the first principle, that there's no defined grief per se, there can be no predictable impact from any of the disparate phenomena we lump under the category of technology. Fixedness starts to disintegrate even further at the realization that no element of this system is stable or reducible. Technology, grief, or any reciprocal impact between them, griever, grieved, or the relationship between them. Blame and calls to action are often directed at technology companies, some of which have teams dedicated to lessening the pain of the bereaved. In 2019, Facebook announced it was making it easier to honor a loved one on Facebook after they pass away, with updates to their handling and management of dead users' profiles. Based on feedback from some users and experts, Facebook problematized phenomena such as birthday reminders from the deceased. These continued reminders they assumed would be distressing for the bereaved. In response, Facebook announced new AI to identify profiles of dead users before they're memorialized to help keep them from showing up in places that might cause distress. On the one hand, Facebook is trying hard to recognize and respond to the wishes of individual mourners, but its attempts to make the interface more bespoke to these users promote a series of assumptions about the impact of the technology on the bereaved and the duty and even ability to eliminate supposed pain points. In their admitted hope to minimize experiences that might be painful, Facebook assumed that automated reminders of the dead cause pain to all grievers, that pain is not what grieving people want or can handle, and that must be designed out, and that is in their responsibility and in their power to do so. They're driven by an instinct to lessen suffering by marshaling grief into something we can control. However, as grief scholars know, even with the best of intentions, attempts to predict and harness grief evolve into norms and expectations to grieve in particular ways. This last assumption also rests on the idea that suffering is negative and best avoided, that grief's ideal direction of travel is toward comfort and away from pain. Our solution to loss or lack of control, a state of being that we're actually in the vast majority of the time with most things, of course, is to scrabble to regain that control. But there are some common phrases within acceptance and commitment therapy, the psychotherapeutic approach that I primarily employ. Control is the problem, and the cost of control. These phrases allude to that understandable human instinct to avoid pain by maintaining or regaining one's sense of control, but highlight also that this strategy often backfires. The attempted solution compounds the original hurt. These problematic, doomed strivings to control emotional experience may be reinforced by the systems that surround us, including social media platforms that attempt to design for grief, designs that are infused with and that may reinforce unhelpful assumptions about ideal grieving. Systems could be designed that allow a window of time in which emotional and practical stakeholders can, with appropriate protections, limits, and safeguards, be able to download an archive of information that was already available to them or that they are legally allowed to have. This would be my preferred option, although there may be issues with it that I haven't anticipated. I propose that given the data privacy and data surfeit drawbacks of indefinite data preservation and availability supersede the benefits, especially when one design can never fit all grievers. So I propose that social media should rethink and walk back policies that attempt to help people in their grief through maintaining, preserving, designing, and shaping of digital remains. The onus is in our legal and regulatory systems to determine the most appropriate contemporary conceptualization of the legal status of such remains, including whether they should retain an element of legal personality or otherwise be enshrined as legally disposable and executable. I hope that in the future, the sole responsibility of social media companies with respect to the data of the deceased will be to efficiently, safely, and sensitively assist with its handling and disposition under the law, which will require customer service resources not currently in place. Blockchain technologies, a decentralized web, and a decoupling of content from applications that allows for clear data ownership may eventually play their parts here. In any case, whether through these means or others, I hope for better, clearer days on the horizon. Thank you.